everyone's time. And just in case you didn't realize, we're going to be recording this meeting. So if you please consent, or otherwise I'm sorry, you have to leave if you don't like being recorded, or just turn off your little camera if you don't want your face on the screen. So we are the Portland Elder Care Council, and we are an alliance of volunteers who are dedicated to helping our community deal with elder care planning issues through a variety of different topics. And really our mission is to help elders, their caregivers, and their families with education and resources to provide clear solutions to difficult problems. And we do this through our bi-monthly webinar series. If you've followed us on social media or are part of our mailing list, thank you for doing that. And that's also how we get out how we are or what our next events are. So make sure you drop your information into the chat box if you would like to make sure you're informed of the next events that we have coming up. So our executive team consists of Bess Lindhall, who is our senior placement specialist director, and she's our director, and Kelsey, who is a realtor, and she is our co-director. And these are the rest of our council members. Whitney Ziegler, who is our right sizing coach, Jamie Levin, our licensed clinical professional counselor. I am Mariah Hurlbert, your money guru, and we have Melissa Swantek, and she is our aging life care manager. And Suzanne Rowe is our guardian and fiduciary specialist. Jennifer Trundy is our elder law attorney, and Nora King is our Medicare plan specialist. And this afternoon, we are going to be hearing from Suzanne and Jennifer speaking on our topic for the evening. So with that, do we have more intro slides? Am I good? Awesome. Okay. So with that, I am going to turn it over to Suzanne and Jennifer to give our webinar presentation for the evening.
Okay. So what we're talking about today is get your ducks in a row. Talking about the importance of a power of attorney, durable power of attorney, and how that can prevent conservatorship, and what they are and how they work. We thought we'd start with what is elder law. Elder law is essentially estate planning plus long-term care planning. Elder law attorneys help clients protect themselves and their estates against unexpected health problems and death. It's nothing against traditional estate planning attorneys, but they don't focus on life and the end of your life as much as they just plan for death and what happens to your assets. We practice protecting our clients and their estate while they're still alive. People are living longer these days. Our healthcare systems have gotten to a point where we're living longer, but not necessarily living better. So we need to have things in place so that when we are incapacitated, we're okay and we have people who can take care of us. And Suzanne, do you want to cover what a professional fiduciary is? You're muted.
Sorry. Hi, everybody. I'm Suzanne. Professional fiduciary is somebody that can make decisions on behalf of somebody else if they are unable to make those decisions on their own. The word fiduciary comes from the Latin word fiedere, which means to trust. So fiduciary is somebody that can be trusted and is given the authority to act as that primary decision maker. In Oregon, a professional fiduciary must be nationally certified, and this certification will allow the courts to appoint that fiduciary to act on that person's behalf.
Okay, so a durable power of attorney, one of the reasons it's important is because it gives somebody permission to act on your behalf. It's basically an employment contract between the principal, which is the employer, and their designated agent, which is the employee. It's not necessarily a, hey, I'm hiring you to do this, but that's essentially the relationship. It has to be in writing and it has to be notarized. The power terminates upon the death or revocation of the power of attorney. I have people come in all the time that say, My mom died, but it's okay. I can handle everything. I'm her power of attorney. And it doesn't work that way. Once the person, the principal or the employer in this case, has passed away, the power of attorney is no longer good. So it still does need to go through probate and everything else needs to happen. In Oregon, a power of attorney is strictly construed. So it's very explicit in what grant of abilities or things that the agent can do. I'm going to apologize. I've had a heck of a day. So it's strictly construed. So if it doesn't say you can do it, you can't as the agent. So if it doesn't say you can change beneficiaries on insurance policy, you can't. If it doesn't say that you can apply for Medicaid on that person's behalf, you can't. So it's very strictly construed. We do see powers of attorney that people have downloaded offline or gotten at a bookstore. And for some people, that's going to be fine. But for the most part, you want it to be as detailed as possible. Can you switch the slide, please? So like pocket knives, powers of attorney documents are created equally. The simple POA from a bookstore might say something like, I give Stu the power to do everything I can do. And that doesn't work. It needs to be very specific. It's like with the pocket knife, you can maybe jab or cut, and that's all you can do. A good durable power of attorney is more like a multi-tool where you have scissors and tweezers and bottle openers and everything else, and you can do a lot of different things with it. And that's what you really need in a good quality power of attorney, especially if you have assets that need protection. If you have a spouse, a well spouse and an ill spouse, it's important to have a power of attorney not only that names somebody to be the power of attorney for usually each other, but have backup plans. I had a case recently where husband and wife were power of attorney for each other, and they didn't have any backups. And the husband ended up having a stroke, and the wife had Alzheimer's, and there wasn't anybody to care for either of them on paper. There wasn't anybody to make those decisions to be able to move people into care facilities. So just because the document is a power of attorney, it doesn't mean that it'll give you the protection you need. It must have that specific language. Most bookstore and online documents don't have that information. But there are some cautions. The most common form of elder abuse occurs when an adult child or niece or nephew or somebody misuses the power of attorney for personal gain. It's a fine line because you want somebody you can trust, but you also want somebody who's going to be able to take action. You don't want somebody who's, people like, my kid can do it, and that's not necessarily the case. I like to tell people that if you are going to go to Belize for 3 months and you handed your checkbook to somebody and you said, here's my checkbook, pay my bills for the next 3 months, and then left without giving them any other instruction, would your bills get paid and would you still have money in your checking account when you get back? If you can't say yes to that, if that person wouldn't be able to figure it out and wouldn't be able to take care of things for you, then it's not the right person to use. Because that's what's likely to happen in the case where your power of attorney needs to act on your behalf, is that they're not going to have a list of instructions of pay my bills, my electric bill on the 3rd and all of that. They're going to have to be able to access your bills and find your bills and figure out where your checkbook is. So, but you definitely want to exercise caution when selecting the agent. You want to avoid an agent with financial difficulties. If your son or daughter can't pay their own bills, it's really unlikely that they're going to be able to pay yours. So it's very important to have somebody who doesn't have financial difficulties, and also someone that isn't going to maybe take some of your money to beef up their bank account. Consider the age of the agent, both young and old. I've had people that want to put their 18-year-old daughter on, which is fine. She's probably going to be 28 by the time she needs it. You need her to use it, or older. But they've also added their sibling. I've got a case right now where it's 2 sisters and they're in their 80s and they're the only other power of attorney for each other. So now one has dementia. So it's been a real difficult situation trying to figure out what to do to get care for both of them. You want to consider the family dynamics in a power of attorney situation. If you've got one child that's super bossy and the rest of them are going to be mad at them and it's going to create drama with the family, you might want to look at somebody outside the family to do that. And then there's springing powers of attorney. In our office, we don't do springing powers. Springing power is when your document says, my son or daughter or agent or whoever it is can't act until I've been declared incompetent by usually two physicians. So what the thought process is somebody will say, well, yeah, I don't want them to be able to access my funds until I need them to, because, you know, once I lose my mind, then they can go ahead and help me out. But if you don't trust them enough when you have capacity to be able to handle your funds on your behalf, then they're probably not the right person for you to trust when you don't have capacity and you can't check into what they're doing and follow up with them that way. The other problem with springing powers, we just had a situation probably 6 or 8 months ago where a mother and daughter came in. Mom does great in the mornings. In the afternoon, she's riding the dementia roller coaster, and she was giving away money, like to people who would call on the phone. And so she would keep having that happen where she was like giving away money, giving away money, giving away money. And her daughter was trying to take control of her assets so she would stop doing that. And the took her to the doctor like 4 times, and every time she went, mom was on the top of her game. So the doctor's like, she's fine. I'm not going to say she's incompetent. It was a beautifully written power of attorney, except for those springing powers. If it had been a standard durable power of attorney that was effective immediately, they wouldn't have had that problem. And then your other option is, if you don't have a family member, or if you don't trust your family members, or if you don't want them to have any drama between them, then you can hire a professional fiduciary like Suzanne. And she just covered what a professional fiduciary does. But there's other options. I've had people use neighbors. I've had people use childhood friends. I've had them use nieces, nephews, siblings, if the sibling isn't going to, you know, only be able to be a power of attorney for a year or so. And I didn't move long enough, so my light just went out in my office. So now I get to do my wiggle dance to get it to come back on, and it's not coming on. So I'm going to sit here in the dark. Oh, there it goes. So Mariah's laughing at me. So what happens if you don't have a durable power of attorney? Many people believe that their spouse, parents, or children can act for them in an emergency situation, or when do they become incapacitated? And that's false. If they don't have a piece of paper saying that they can act on your behalf, they cannot act on your behalf. Don't distract me, Ryan. So emergencies and incapacity can happen at every age. That's another thing. I have a lot of clients that will come in and say, you only want me to do all this paperwork because I'm getting old. Those are my daughters right there. They're 25 and 27. They both have had durable powers of attorney and health directives since they turned 18. And that was before I was an attorney. My older daughter, one on the taller one, the curly hair, she took a class in high school on bioethics and studied the Terry Schiavo case and saw how the families argued and tried to keep her alive. And so she's like, I don't want that to happen. So she talked to an attorney friend of mine and had it drawn up when she was 17 and signed it when she turned 18. So it's not just because somebody's old. I think everybody should have a power of attorney and an advance directive, no matter what their age. Because if you're 18 or 81, it's important to have a power of attorney so your agent is able to handle your affairs if you are unable. So in some cases, people don't have a power of attorney, or it's no longer effective, or the person that they've assigned as the power of attorney can no longer help them, like we discussed. So let's look at what happened to Dorothy, and Suzanne's going to take us through that.
Thanks, Jennifer. Let's talk about Dorothy. Dorothy is 89 years old. She lives in her home in Portland. She never had any children. She was married, and she had her husband Harvey as her durable power of attorney, which they signed in 1975. She also added her friend Nancy as her backup POA, but unfortunately, Nancy, she has passed away too. So now Dorothy has been living in her home alone in Portland, and unfortunately, she's been diagnosed with Alzheimer's. So because of Dorothy's Alzheimer's diagnosis, she's been unable to handle her daily, monthly bills, her property taxes, things of that nature. She's very fortunate that she has really great neighbors around her that keep an eye on her. And they've been neighbors of Dorothy's for a really long time. But they start noticing that the house is in disrepair, it needs some upkeep, she's not able to do it any longer. And then they notice that Dorothy's lights aren't on at night. They see that the house is completely dark. When they talk to Dorothy, the neighbors have learned that unfortunately, Dorothy's electricity was disconnected and she no longer has power in her house. This is because she wasn't able to pay her bill. So her neighbors, having her best interest at heart and not knowing what to do or how best to help her, have contacted Adult Protective Services. And what happens now? How can Dorothy be helped? Well, Adult Protective Services will come out and do an investigation, and they'll learn about Dorothy's living situation. Is she able to care for herself? Is she able to handle her finances and things of that nature? Is she safe to live at home any longer by herself? Could she be the subject of undue influence of people that might be telephoning her with these scam calls and elder abuse in that regard? Could she be subject to some undue influence from perhaps a neighbor that isn't so trusted? Maybe Dorothy is a candidate for a conservatorship. And a conservatorship is a court appointment whereby somebody is selected to act as a conservator for somebody who is unable to handle their own finances. And somebody wouldn't need a conservator for somebody like Dorothy. She's not able to handle her bills. They come in the mail, she just puts them aside. She doesn't know what to do with them, so she just doesn't pay them. A conservator might also come into play when somebody doesn't have a backup power of attorney or a power of attorney that they have named that can help them in a situation like this. So if you have a named power of attorney and they're no longer living, like Harvey, or a backup like Nancy, her friend, then who's going to make these decisions and help Dorothy make sure that the bills get paid and that she's got lights on in her house and heat? Who can be a conservator? Well, it could be a friend. It could be a family member. It could be a professional fiduciary like myself. It could be a neighbor. It could be anybody that could be a trusted protector for that proposed protected person. So if you, sometimes I've seen neighbors or siblings become conservator for somebody like Dorothy. If that person kind of, as what Jennifer said, can be trusted, is handling their own finances well, is responsible in paying their own bills, that might be a good person to be a conservator for Dorothy. But if there's not anybody in her life like that, then perhaps maybe a professional needs to be appointed. And how does somebody become a conservator? Well, there's a court process for that. The process for a conservator through the courts is a very important process. Conservatorship means you're basically taking that person's rights away to make financial decisions for themselves, to handle their finances, to perhaps sell property or vehicles, things of that nature. So you want to make sure that whoever is becoming the conservator in the court process is somebody that has good business sense and has ability and responsibility to pay bills. The court process starts with a petition for conservatorship, and that has to be drawn up by an attorney. And in that petition, you would name the protected person, that would be Dorothy, and then the proposed person to be the conservator. In that petition, there are basic demographics about Dorothy, and then there's some information about the proposed conservator and and some information as to why Dorothy would need a conservator at that point in her life. Once it is filed with the court, there is a notice period. And Dorothy gets notice of this conservatorship petition. She has an opportunity to object. If she chooses to object to somebody stepping in and helping her, then the whole process might end up in a court hearing. If she decides that, yes, I really think that I need help and I really want to have this professional fiduciary help me and pay my bills and get me out of this mess, and then she may not object to that appointment. So in that process, she's got 15 days to make an objection to that proposed appointment. If she doesn't make that objection, then documents are filed with the court in terms of a limited judgment by the attorney who's done the paperwork for the proposed conservator. And once that limited judgment is signed by the judge and the judge sees that no objection has been made, then they will issue what's called letters of conservatorship. And even though it's called letters, it's one piece of paper, and it's the document the court provides to the conservator. That is the official document that allows a conservator to act on behalf of that proposed protected person. So what can a conservator do? So as a conservator, you can, in Dorothy's case, the first thing I would do, I would contact all of her household utility and house maintenance, garbage, phone, and have them have my documents on file, get the most current billing statements. I would also contact her financial institution right away and present my documents to her bank and let them know that I'll be taking over to help Dorothy pay her bills. Sometimes that can be a bit of a process of getting banks to accept and acknowledge letters of conservatorship and an assigned limited judgment. But it might take a little while, but usually most of them do. And then you can start making payments on Dorothy's bills. And I would also look into her property taxes. Have those been paid? Are there other things that need to be paid on Dorothy's behalf? I would also perhaps maybe get her mail forwarded to my home or to my office so that I can see maybe that there's other bills that may not be apparent, that maybe only come quarterly, something like that, that I would be able to pay on Dorothy's behalf. So there are certain things that a conservator cannot do. A conservator cannot make medical or personal decisions. A conservator can only make financial decisions. And so that, like I said, would include marshaling the assets. So maybe Dorothy needs to go to a memory care community. The conservator does not have any authority to help place Dorothy in a memory care community. The conservator would be able to contact the memory care to say, I was responsible for her monthly room and board, so please send me her bills. And so those are the types of things that conservator can do and cannot do. A conservator can also not change designations on beneficiaries without court approval. A conservator cannot pay themselves from the funds of the protected person without court approval. A conservator cannot sell a car without the original title. A conservator cannot access perhaps a safe deposit box without contacting the bank and having letters of conservatorship on file with that financial institution. What the conservator must do, the conservator must at all times act in the very best interest on Dorothy's behalf. And they must make timely payments of all of her bills. A conservator must also file an inventory within the first 90 days of her or his appointment. This inventory is a list of all of the assets that they discovered that belonged to Dorothy. So that would include bank accounts, her home. That would include any vehicles, any financial accounts, investment or brokerage accounts. So all of these types of informations would need to be included in an inventory. And then on an annual basis, the conservator must file an annual accounting with the court. And that annual accounting includes everything that has come into and gone out of Dorothy's conservatorship banking account, a separate account set up under the conservatorship. So the court does highly scrutinize what the conservator does. There are audits done on these annual accountings. And if they're not filed in a timely fashion, then the court will have the attorney and the fiduciary come in for a court hearing asking why. The courts are very protective of the people that are under conservatorship. And so the conservator must act in every way possible to do the exact right thing in order to protect Dorothy. Does a conservator get compensated? The conservator can be compensated if it's a family member or a neighbor. They certainly can be compensated. Sometimes maybe the family or friends will waive being compensated for the work that they do. However, if you are going to be compensated, you should keep track of the time of everything that you do, paying the bills and meeting with banks and investment brokers and things like that. As I mentioned before, if you are going to be taking payment for the work that you do on Dorothy's behalf, then it has to be filed with the court to get approval to pay yourself. And those fees are paid for from Dorothy's funds. So that doesn't come out of the pocket of anybody else but Dorothy in this case. So that is how you get paid as a conservator. So that's really all I have. Do you want to say anything, Jennifer?
I just wanted to say that there are more aspects to both of these. You do need to have a health power of attorney or an advance directive, which is a combination health power of attorney and living will. And if you don't have that, then you might need a guardianship. And we are going to cover that at our next meeting. We kind of split the topic into two because it's a lot to cover at one time. So the next meeting, I think, is in July or August. Is it August? So if you signed up for today and you're on our email list, you're going to get a reminder of our next events. And if you go to portlandeldercarecouncil.com, then you can find our future events. We have them in all sorts of different topics. So, and there, I believe, are recorded versions of previous webinars there that you can watch. So, but I wanted to thank you all for coming as well. And I'll turn it back over to Mariah to close us out.
Oh, good.
Some questions.
Yeah, I was gonna say, just this would be a great time if there was anything that you heard that you wanted a little bit more clarification on, or any questions that you have. You basically have an attorney and a fiduciary for free to ask a couple questions to right now, so you should take advantage of it. No takers.
No takers.
I actually
You
have a
guys know
question.
everything.
No, I don't know everything, and I do have a question. Jennifer, I know you mentioned and you touched on springing powers. I'm still struggling to understand that concept. I wondered if you could talk a little bit more about it.
Sure.
And the relevance of it.
Sure. So the traditional power of attorney is effective immediately as you sign it. So that when you sign it, the person you've assigned as your agent can use that immediately. People use it all the time. I was an Air Force wife, and we'd move and I would use my husband's power of attorney that I had. I was his agent on it to close on our house, to set up utilities, to do things like that that we both needed to sign. And that's one of the things you can do with the durable power of attorney. I've got durable power of attorney for both of my daughters, and I was able to help one of them deal with an insurance thing, which otherwise they wouldn't have talked to me. So you can use that. It's choosing the person that you want to have use it correctly. a springing power of attorney, and the reason it's called springing is that it doesn't spring into action or spring into effect until the person, the principal, the person who is assigning the power of attorney, abilities to, is declared incapacitated or incompetent. So a lot of people are like, well, I don't want my son or daughter or whoever to have access to my bank accounts until I've lost capacity. And we don't do those. It's just, if you don't trust the person enough that you don't trust them when you are paying attention and know what's going on to your bank accounts, then you shouldn't trust them later. And I've actually had several lately where they've come in with old estate plans that have springing powers of attorney, and we've rewritten their powers of attorney to be, immediately effective. And since I mentioned bank accounts, I'm going to get on my little soapbox for a minute. Don't have anybody other than your spouse or like business partner on your bank accounts. We have it all of the time where people will add their children to bank accounts. If you want to add a child or somebody else as a co-signer, that's fine. Don't add them as a co-owner of your bank account. And vice versa, don't have your parent as a co-owner once you're, of age and are making some money. Because if something happens to that person, so if I added my daughter to my bank account and then she was in a car accident and her insurance wasn't enough to cover all of the medical damage to the person that she was in the accident with, and they sued her, because she's a co-owner on my bank account, all of my funds are then available for the lawsuit. So you don't want somebody as a co-owner. The other thing that can happen, I recently had a case where somebody was trying to qualify for Medicaid and the parents didn't have much money, but they were co-owners, the parents and their kids, they were like 8 bank accounts together, intermingled. So now to qualify for Medicaid, which is a complete different conversation, they're counting the kids' assets as the parents' assets and are including them in their spend down. So instead of being qualified based on their current assets, they're probably going to have to spend down about $90,000. That is their kids' money. So you don't want to have co-owners on your bank account other than your spouse or life partner or somebody that you want to commingle your accounts with and that you would use in that way, where you're just using it because you're working together. If you have to have somebody on a bank account make it a small account that doesn't have very much in it. But you really don't want to. You want to add them as a signer on the account if you want to have them. But if they're going to be a signer on your account, you should probably make them your power of attorney and make it official. So there's my thoughts.
That actually makes me think about two like larger aspects, such as your home. Should that be put in a trust instead of having it in each spouse's name? Because I think of it like along the same line of protecting assets, right? If something should happen, liability.
Well, liability, you want it in both spouses' names. There's multiple reasons to not have your children on your house. One would be the asset situation. The second would be step-up basis for taxes, for capital gains taxes. You can add them as a payable on death do a deed that transfers on death to that person to avoid probate. But if you do that, they can't sell the house for 18 months. The main reason people are concerned about their house and dealing with it is they don't want to go through probate. Probate's not a horrible thing. It is a process, but they've been doing it forever. So that's when a lot of people will do a trust, because the money goes, the house is in the trust owns it, it's an entity doesn't die. So probate is when we divide up the assets of somebody who has died, because they no longer have the right, because they're gone, to sell the property or do anything with it. And there's nobody else who has that right. So husband and wife, it's fine to have it as a combination of both, or, wife and wife, or husband and husband, or life partners, however that is. And you can do a right of survivorship on that, so that if one of you dies, the other one gets the property. It's further on down the line that you want to start doing things possibly in a trust if you don't want to have to go through probate. There's some Medicaid reasons for moving houses out of one spouse's name and into the other, but that's a huge, longer conversation.
Jennifer, would a secondary trustee be considered that spring trustee that you were talking about?
So there's a difference between an agent on your power of attorney and your trustee or your successor trustee on your trust. So the successor trustee on your trust, or actually any trustee on your trust, only has the ability to control the assets that are in the trust. And I like to look like a trust is like a treasure box, and that's the paperwork, and we build this trust. Then you have to put all of your assets in it. A power of attorney covers the things that aren't in the trust. The trustee will handle the sale of the house or things with bank accounts that are in the trust. A trustee is not necessarily going to be able to handle insurance policies or applying for Medicaid or applying for Social Security or paying your taxes or talking to the IRS or handling a divorce. We've had that happen where people, dad's incapacitated and mom files for divorce. And so now son has to act as power of attorney to handle the divorce. We don't do divorces, but we've had the situation come up where they've got a power of attorney. So now son is representing dad against mom because mom filed for divorce and dad doesn't have the capacity to be in court on his own. So the son has to do it. So there's a lot of things. Our powers of attorney documents are 25 to 27 pages long, 25 to 28 pages long, because there's so many little details in there. Transferring mail, the trustee can't transfer your mail. Dealing with your pets, taking them to the vet, signing for things like that. We put that in a power of attorney. Arranging for companionship, like signing a contract to work with Jamie, that type of thing. That's all goes into our powers of attorney. So they're a pretty robust document.
How long does that appointment take with a client to really suss out the power of attorney documentation? And what's the typical cost of that too?
Okay, so in our office, a power of attorney is $400 for one person. We do have different packages that combine them so that you can do a power of attorney, will, everything together. But power of attorney, I've done them very quickly. I did one a couple days ago where they called at noon and I was at an assisted living at 3 o'clock doing a power of attorney. So if I have to do it quickly, I can. I do have to speak to the person who is assigning the power of attorney. I have people all the time that call and say, you need to give me a power of attorney for my mom. Well, your mom needs to ask me for the power of attorney. Well, she's incapacitated or she's in a coma or she's whatever. I'm like, I can't do anything because she has to be able to sign it saying that she's granting that authority over to you. Otherwise, you have to get a guardianship or conservatorship or both. So, other questions?
Really good info.
Thank you.
Anyone else?
Anyone else?
Awesome.
Jennifer, since we have 20 minutes left, can we just sort of work on our power of attorneys right now with you for free? Just kidding. That's unreasonable.
Yeah. No, actually, anybody who is on the call today, I don't know what the rule is on if I give my contact information. So, but anybody who's on the call today, if you reach out to Portland Elder Care Council and ask for a free attorney 30-minute consult, they'll connect you with me and you can make the appointment. Just tell our admin that you were on the Portland Elder Care Council call and that you're entitled to a 30-minute free consultation, and we can talk about what you need to do for estate planning. I'm not going to talk to you about divorce or landlord tenant or anything like that. But if it's estate planning, elder law, protected person situations, probate, anything like that, I can help you with that.
Jennifer, it looks like there is a question that came in the chat from Christina asking, why do people think that their spouse can act as a power of attorney?
So I think because they just assume that because they're on the same checking account and they're on the house together, that they can just do everything together. And it's just not, it doesn't work that way. And people just assume that once your spouse can do stuff with you and for you that they can do everything legally related and they can't. A power of attorney can form a trust for somebody. They cannot do a will. So a will, you have to have the actual testator, the person doing the will. A power of attorney can do a HIPAA for you, which is a HIPAA waiver to release medical records. A power of attorney cannot do an advance directive for you. So power of attorney, advance directive and will, you actually have to have the actual person sign it. And I've had people that can't physically sign, but they can communicate with me. And if they can make a mark, I can notarize it and do that. I've had people who can't even make a mark, but they can still communicate. And as long as I understand what they're saying, they can give permission to somebody else to act on their behalf. And then I notarize both documents. So there's ways around things. I had one yesterday where his mark is he has a stamp with his name on it because he can't write anymore. He can handle the stamp, but he doesn't have enough hand control. So
Jennifer, I know
answer the
you
question?
can't maybe give out your contact information, but if one of us were to put the contact information in the chat, that wouldn't violate anything.
I don't know. That would be a Kelsey question. So
It's probably best that we go through it just until we find out. We're kind of in the middle of figuring out everything right now, but if you send it to the Portland Elder Care Council, we'll definitely forward it on.
or if you Googled my name, you'd probably find me.
Yeah.
Just a hint.
Her name is on the bottom of her picture if you need help with the spelling.
Just add lawyer behind that.
Yeah.
Because you'll find all sorts of other things out there about me. Google me.
Erin, did you have a question? I saw you came off of mute.
No, I was just asking if we could put her contact information in the chat.
Oh, perfect.
Trying to be helpful.
Yeah. Well, if there aren't any other questions, that is the end of our programming this evening. Thank everyone again for coming and joining us, and we look forward to seeing you at our next event in August. Perfect.
Thank you.
Thank you so much, everyone, for joining us.
Thank you.
Thank you.